Well, here we are. We're back and we're talking about Oliver Mause Barker-Vormawor and what has transpired post that post playing on words on social media and his being labeled a coup monger. Well, he's been granted bail. Initially, he still had to remain in custody on the back of certain signings that had to be done and certain confirmations on his bail sureties. Well, all of that done now, and he posted on social media with some image on social media with a lot of responses, if you like. But joining me in the studio, I have here my own colleague, Joseph Akable, and he will be walking us through what exactly has transpired over these last few weeks that Oliver Barker-Vormawor has been in custody. We also have lawyer Bobby Banson joining the conversation. He will be telling us about the legal dimensions to what we've seen and what we can expect. Can the state prosecute? Do they have what it takes? We'll find out. But let's start in the studio. Mr. Akable, a very good morning.
Hello, Ben. Good morning.
Yeah, you like that? Mr. Akable.
It makes me feel a bit old.
I intentionally did that. Anyway, let's get into the serious matters. What exactly has transpired within the last few weeks that Oliver Barker-Vormawor has been in custody? What in fact led to that? Just a quick take on the entire trajectory.
I mean, there have been a number of Facebook posts. I mean, Oliver Barker-Vormawor is quite active on social media, and so he made a series of Facebook posts, one which indicated that if the e-levy policy is passed, he will do the coup himself. Mm-hmm. There are others that he had welcomed.
Useless military.
Useless military. There are others that he had welcomed coup d'etats in various countries, among other things. And so on February 11, he arrived in Ghana from the United Kingdom. When he got down, he was arrested at Kotoka International Airport. Now, this was on a Friday. On Monday, the state took him to the district court at Ashaiman, where he was slapped with a charge of treason felony. Now, the fact that was filed, attached to the charge sheet that was filed, indicates that the allegation is that the Ashaiman police received a complaint that an individual, that is Oliver Barker-Vormawor, was inciting members of the Fix the Country group to engage in the overthrow of government. And so the police said they mounted a surveillance, and afterwards they saw a series of posts that they believe amounts to inciting his followers to stage that coup. The fact sheet ends by saying that in furtherance of that objective, he arrived in Ghana on February 11, and that is how come he was arrested. And so the police told the Ashaiman District Court on the 13th that they were continuing with investigation. And so, I mean, at that point in time, his lawyers had asked that he be left to go, in simple terms, because the argument they had made was that when he was arrested on Friday, it meant that the 48-hour rule per the Martin Pebu and Attorney General case would have meant that he should have been taken to court either on a Saturday or on a Sunday. But they rather took him to court on Monday. They also make the argument that if you read the constitutional requirements, he should be taken to court. And they say that in the interpretation section of the Constitution, a court is defined as one of competent jurisdiction. And so their argument was that he should have been taken to a court that has the capacity to make pronouncements that affect his liberty.
Exactly.
But the court disagreed and
that has to do with the bail term.
The bail term. So the court disagreed and remanded him into police custody. Then his lawyers filed an application for habeas corpus at the Tema High Court. And at the Tema High Court, they were simply saying that, look, when he was even remanded at the district court, the judge's order, they said the order didn't say that he's been remanded into police custody. And so it meant that the police did not have a warrant to have kept him. But nonetheless, they kept him in their custody.
They kept him all the same.
All the same. And also raising issues about the fact that he was not taken to a court of competent jurisdiction in their opinion within the 48 hours. The Tema High Court disagreed with them and advised that they should actually make an application for bail, just like the district court had also advised. But they sought the intervention of the Supreme Court, seeking a certiorari to quash the Tema High Court decision. And the Supreme Court disagreed with them as well, saying that there was nothing wrong with the decision of the High Court. If they have concerns, then the appropriate issue to do is to either appeal that decision at the Court of Appeal, because the certiorari they were seeking to do, there was no obvious error that requires the intervention of the Supreme Court. The Supreme Court at that level also did advise that they should make an application for bail, and also questioned what they called the lawyers being engaged in an intellectual exercise when the liberty of an individual was at stake.
Was in question.
Right. That was at the Supreme Court. Then after the Supreme Court decision, they went to the High Court to this time make an application for bail, where they explain that he's going to show up. But it's worth pointing out that the Supreme Court, the justices asked the AG's office whether they will be opposed to bail should an application be made at the High Court. The Deputy AG, Diana Sunamba Dapa, told the court that the state may not oppose bail if it goes to the High Court. But we saw subsequently that at the time High Court, when the application for bail was filed, the state opposed it and accused Oliver Barker-Vormawor of not cooperating with investigations. And so, in between making that argument at the Tema High Court, the case went back to the Ashaman District Court where the committal is supposed to take place. And at that level too, we know that the prosecutors didn't show up on that day. And the magistrate, she's actually a circuit court judge sitting as an additional magistrate, expressed reservations about the conduct of the prosecutors and calling for seriousness to be attached to this particular
case. They were not showing up and all of that. Which also put into question the processes leading to his bail, because once they were not showing up, it had implications on the entire process.
So this was at the district court. Then back at the High Court for the ruling, Justice Daniel Mensah granted Oliver 2 million CD bail with two sureties. One is to provide the documents, which was what became a new controversy that was supposed to be justified, and it took a bit of time. That's according to the police. But if you listen to the Face the Country movement, they believe that it was part of a grand scheme. So this is by way of the key about 7 timelines of where we've come from since February 11, and we know that yesterday he got his temporary freedom of sorts eventually.
Right. And with that, charge of treason felony hanging over his head, I really don't know how he would be feeling. But I guess at some point we would get to interact with him. But let me bring in Bobby Banson now. He's a lawyer. Bobby, so you've clearly followed this case. I would just like your initial reaction to all that has transpired, culminating in Oliver finally getting bail, the 48-hour requirements, and even the talk from the likes of Akoto Ampaw and others that clearly he may have been talking and he may have said certain things that he shouldn't have, but in the end, was he capable of actually staging a coup? But let's start with what your understanding is of what has happened throughout up to this point.
Good morning to you and to your viewers and listeners. I think your colleague, Mr. Akabley, has narrated the sequence of events very clearly and puts the discussion in that very good context. I'll be too careful to try and discuss whether he's capable of carrying out the threat he put on his Facebook page or not. That would be, for me, purely speculative. It's a factual issue.
I was really talking about something that one of his own counsel, I'm talking about Akoto Ampaw, had said, pointing to the fact that, yes, it may have been reckless comments, but was this serious? Was this an individual? I mean, I was just alluding to that.
Yes, I understand. But, as him being counsel, of course, that will be one of the defenses that they would put up. And I will not begrudge them if they do. At the end of the day, the courts would have to look at whether or not there was any intention behind the statement he made. Whether he's capable of staging the coup or he's not capable of staging the coup is a burden on him or his counsel to prove. And if the fact is that he had communicated an intention to, is that in itself a fact that somebody could be tried on for treason? So I would want to leave that aspect, except that with the for what lawyers would refer to as the legal gymnastics that have gone on in an attempt to procure him bail. I think it's a further improvement of our jurisprudence on this subject. Mr. Martin Pebu, before this, you would recall that the position of the law had been that certain offenses are unbailable.
Right, non-bailable offenses.
Went to court, yes, for the Supreme Court to say no, every offense is bailable.
Right.
So if this matter had happened pre-Martin Pebu versus Attorney General, then we wouldn't have even been talking about bail, because then the court would have said, listen, it is under Section 96 unbailable. But once that 96 was struck out by the Constitution, by the Supreme Court because of Senior Pebu's brief, then the issue of whether it is bailable does not come in. Now, if it is bailable, what are the conditions that must be set? It's purely at the discretion of the judge. If the trial judge gives conditions for bail and the accused person thinks that those conditions are harsh, burdensome, and impracticable, he has a right to appeal against the bail conditions and even apply for bail pending that appeal. So the procedure is quite clear. At the end of the day,
do you feel, Lawyer Bobby Banson, for the sake of time, do you feel we've made a mockery of, in a way? I mean, in the end, bail has been granted Oliver Barker-Vormawor, but the Martin Kpebu decision, and of course, you've talked about what exactly it took to get to this point in our jurisprudence, but do you feel we've made a mockery of that ruling in terms of how we've handled Oliver Barker-Vormawor and the officers who should sign, or the officers who should be appearing in court and all of that, who have not done so? Was this victimization, if you like, or taking advantage of the powers of state to sort of punish an individual who spoke out of turn? I want you to be blunt with it.
Let me be very blunt. What happened to him in satisfying the bail conditions in terms of the administrative procedures is not peculiar to him. It's unfortunate that it happened to him, but I'll be lying if I say that it happened. He's the only one that has suffered these consequences. The ordinary Joe, every time.
But the fact that others suffer it also, that doesn't normalize it. I mean, does it? It doesn't normalize it.
No, it's because you said whether he's been victimized. I'm not saying it is right.
Right.
Because of the perception that they are doing it to only him.
Right.
And that is what I sought to say, that I don't think that any person that has experienced the criminal justice system in Ghana would say that it's happening because it is Oliver. It's unfortunate it has happened. It is wrong. It must be condemned. But it is not only him. The administrative procedures must be changed. Because, for instance, when the court gives the bail condition that it must be secured with a landed property, the surety who brings the landed property would bring his documents. The court registrar must confirm that the documents are genuine. It is only the Lands Commission that can certify documents as genuine.
Right.
So depending on the time of the day that you bring these documents to the court registrar, the court registrar will now have to send it to the Lands Commission. And the Lands Commission is not digital. It's not as if they go behind a laptop, they type the name, and it shows whether it is genuine or not. It's manual. They have to go and look for the file and pull it up. So in that instance, it gets out of the hands of the registrar of the court.
Right.
So for instance, if you bring your document at 2 p.m. and the Lands Commission closes, let's say 4 p.m. or 5 p.m.
So all of that comes
gets
into the picture.
Exactly.
Right.
So I would not say that it is the best system, but I would also be slow to say that they intentionally did it to delay Mr. Oliver. I would be very slow to, because every person that has experienced the criminal justice system, especially satisfying bail conditions, will tell you that it is not strange.
It's not strange. It's not straightforward. Permit me, Bobby Banson, to just wrap the conversation with you on this. Now, looking at everything that has happened, some have said treason, felony. I mean, when it comes to murder, for example, you must prove beyond reasonable doubt, because the penalties for same are long-standing. They can impact someone's life very negatively. Again, when it comes to treason, felony, we're bordering on the same lines. You must prove beyond reasonable doubt. Some have said that the state does not have watertight, ironclad evidence in this instance. What is your reading of that?
I think like every criminal matter, the burden on the state will be, like you said, to prove beyond reasonable doubt. From the facts that is available to the public, what has been contained in the charge sheet, I don't want to think that the state, or I'll be slow to conclude that the state will be able to discharge that burden based on the facts available to the public.
Right.
But this is a security matter. If the state would have further evidence that they've not yet made available to the public because of the security nature of it, then we will not want to belittle their case. Mind you, it will be very strange for the Republic of Ghana, with the involvement of the Attorney General, to bring a charge as sensitive as treason when it does not have evidence to support it. They better withdraw the charge or enter nolle prosequi.
We've seen, though I want you to wrap quickly on this, we've seen in the past instances, you remember the earlier accounts of Dr. Do you remember his name? McPalm? Yeah. Dr. McPalm and others. I mean, where has that ended? It's still,
No, the trial,
but I'm just saying that it's not been executed.
Yes, but I think the trial is still ongoing on that. There's a treason trial that I'm aware is still ongoing in respect of that. And so I would want to see the evidence that the state would come up. But it would be very interesting for our constitutional and criminal justice system if the state decides to enter nolle prosequi because it doesn't have the evidence to support the charge. Then we'll all sit and say, okay, so you were wasting everybody's time. And then the gentleman would have a right under the Constitution to sue for wrongful detention, as it were, for the period that he has spent and get damages. We have that precedent in our system.
Well, Vivanson, it's been insightful. Thank you so much for sharing your thoughts with us this morning. We're grateful. I'd also like to say thank you to Joseph Akabley for walking us through what exactly has been happening. I am itching, for someone interested in legal matters, I am itching to see how this eventually pans out, because it adds to our jurisprudence. It also adds to, how exactly we tackle some of these matters moving forward. Thank you so much, Joseph. Well, coming up next, we're going to be talking about a figure who has been here for a quarter of a century. In the media space, I mean. You want to know whom? Stay with us. She's up next.